And over to you, Chris, to take it from here.
Okay, thanks a lot, Angus. I'm Chris Dias. For those of you who saw me last week, welcome back. And for anybody who's new today, I've got a bit of a blurb about myself here, giving you a background. I'm a fully qualified solicitor. I've been practicing exclusively in immigration law since 2001, and I specialize in sponsor license applications, skilled worker visas, which is the new name for Tier 2, and also for individual immigration as well. So the whole gamut of immigration, really. If you need anything in that area, please do reach out to me. So today we're going to be talking about the skilled worker route, and this is especially relevant this year, 2021, because the UK has left the European Union, and now, as the government put it, we now have a level playing field between new nationals coming in from the European Union and workers coming in from the rest of the world. We all have to now follow the same rules, the skilled worker route for employment. A reminder, though, that we do still have the EU settlement scheme, which is what I talked about in detail last week. So we have legacy workers who were here prior to the 31st December 2020, who had the opportunity to apply under the EU settlement scheme to preserve their right to live and work in the United Kingdom without having sponsorship under this new scheme. And obviously that's really important that people do those type of applications and secure their status. Again, last week we talked about that there's still the opportunity after the 30th of June to put in late applications if you missed out or you didn't understand that you had to apply. So if when you're dealing with your employees, especially European employees, and something comes up, please do reach out to us. We can help them put in a late application rather than them losing their right to live and work in the UK. However, new workers coming into the UK from the EU from the 1st of January 2021 already have to now qualify under the skilled worker route. So there's a clear distinction there. So what is the skilled worker route? This is the new name for Tier 2. We had the points-based system. The government are slowly renovating that, as every new government likes to do, tinkering with immigration rules, but especially because of Brexit. But there have been some really positive things from an employer's perspective in the new skilled worker system. And I've pointed these out on the slide here. The base salary for workers is now much lower than it used to be under the old system. It's gone down by £5,000 from 30 grand plus to £25,000. So a big difference in the base salary. And along with that, the job skill level has lowered as well. It used to be level 6 jobs, which was equivalent to graduate level jobs. But now, as of January the 1st, it's level 3 jobs, which is roughly equivalent to A-level skill level. And this has really opened up the type of jobs that you can get a skilled worker visa for. I'm roughly doubling the amount of jobs you can get it for. So it's a really positive development. For anybody who's ever had to apply for a worker visa, this is quite a significant development, that there's no longer a requirement to advertise the vacancy to local workers. If you find someone that you want to sponsor, you can go straight to the sponsorship without having to justify it. So how do you go ahead with sponsorship? Well, firstly, you need a sponsor license. So it used to be under the old work permit regulations many moons ago that any company could just apply for a worker when they needed it. Now you need to get a special license before you can start sponsoring workers, and there's an application process to do so. It's called a sponsor license, and you join the register of sponsors. And at the moment, the figures show that, well, at least up to 2020, there were less than 5% of UK employers holding such a license. I know from my own practice that there's a sudden surge of applications now that Brexit has happened, and I spend a lot of my time doing these type of applications. So I don't know how the figure is going to look at the end of the year, but certainly it's still, I think, in single digits as to percentage-wise of companies that have a license. So certainly getting a license will put you at an advantage compared to your competitors, I think. With regards to once you have a license, it lasts for 4 years. So the license application is only once every 4 years. When you have a sponsor license application, well, when you're making a sponsor license application, it's an online application. So you fill out a form online, you pay a fee online, depending on the size of your organization, and then you have to provide certain documentary evidence to the Home Office to prove that you're a genuine organization and that you have the right procedures in place and the right registrations. You have to have a letter from your director as well, explaining to the Home Office why you're applying. They want to know. It's not something you just apply for. They want to know what's the reasoning behind it. And then as part of the application process, you may be visited by an officer from the Home Office who will come to your office, want to speak to you, the HR manager, maybe one of the directors, and again, go into a bit more detail as to why you're applying. And they may well even go to the point of auditing some of your files, looking at your HR procedures, just to make sure you understand and you have the right procedures in place to meet your sponsor duties. The application process at the moment is taking about 8 weeks. And I think that shows how busy they are with applications. It certainly, a few years ago was not taking this long at all. So there has been a development in that. And I think as the applications, as it becomes more widely known, it may well get longer, the application process. So once you have a license, as I said, it's valid for 4 years, but then for each work you want to sponsor, you have to issue what's called a certificate of sponsorship. That's or known as a COS. But there's 2 different types of COS that you can issue. One's called an undefined COS, and this you're given an allocation normally at the start of each year by the Home Office, and you're free to issue these as you please. And if you run out of your allocation, you can even ask for more. And these are for specific types of workers. So people who are already in the UK, such as existing staff who need to extend their permits, workers who are working for another company and want to switch employers, and even students who you want to recruit once they finish their studies in the UK. But if you want to recruit someone from outside of the UK who's not based in the UK, that's where a defined cost comes in. And these ones, the Home Office are still controlling the issue of those. So you have to apply on a case-by-case basis to the Home Office for one of these through their own sponsor management system. And these you have to then apply for, and they issue it before the worker can actually then apply for their visa. So there's a 2-stage process. Process 1, you apply for the cost, then process 2, they apply for the visa. And there's no guarantee that just because you gave them the cost that they'll get the visa. So always good to get some immigration advice before you go through this process, because there's always a cost as well of getting these certificates from the Home Office. It's a money-making business, guys. Once you sponsor somebody under a skilled worker visa, once you've issued them with the costs, they have to apply for the visa, and they're expected to be working full time for you as the sponsor, and that's defined as between 30 to 40 hours per week. They are permitted to take secondary employment above that, as long as it doesn't interfere with their primary sponsorship to work for the UK company that is sponsoring them. Visa length, that's again based on the employer who sponsors them. You can specify anything between 1 to 5 years. and the cost you pay to the Home Office is proportionate to that. It goes up per year. You can sponsor up to 5 years in one go, or a lot of sponsors maybe try 2 years and then renew if the worker is still needed after that. So there's some flexibility there as to how you sponsor. And the big advantage for the worker is that they're allowed to bring their partner and any child under 18 into the UK, and they have full rights in the UK. So the partner can work for anybody, is not tied to one employer. The children can go to UK schools without having to pay private fees, unless they want to. So it's a very attractive visa to have, and certainly makes UK companies very competitive on the worldwide marketplace, I think. So that is my brief lunchtime summary for you guys. I hope you enjoyed it. If you have any questions, please do let us know, and we can discuss that either now or in a future one-to-one consultation.
Brilliant, thanks, Chris. Yes, I mean, as you're aware, this was a very much we know that your lunchtimes are precious, so we wanted to give you an overview of what the change position is, and that was really exactly what we've heard from Chris. So thanks for that. So there's a number of questions that certainly occurred to me during the course of this. One thing was just in relation to the defined costs. Certificates of sponsorship. Is there still a quota system in place where the government can effectively turn the tap on or off, or increase the flow by changing the quotas of certificates that are available, and then there's a mad scramble on the date that they become available?
No, interestingly, they stopped the quota system for the moment, but there is a facility that they can turn it back on very easily if they think that they want to start controlling it again. I think the reason they've made it so easy is because they want to reassure employers that there's not going to be these huge shortages from the lack of European workers. But certainly as we move forward, the government have the ability to start restricting again.
I see. No, that's
sorry, just to follow up on that, Angus. I seem to remember, Chris, that back in the day, you used to have to announce your planned recruitment activity and get an advance allocation of certificates of sponsorship. But are we saying that's not now the case? You don't have to sort of plan ahead.
That's only for the undefined ones now. So, for example, if you know a certain proportion of your workforce will need to renew their visas that year, or if you know you're going to have a certain amount of graduate recruitment where you'll be able to use the undefined ones, then you can still do that.
Right. That's helpful. Thank you.
And you mentioned also, Chris, there's no need to advertise locally, and this takes me back to the days when quite often there would be an individual that an employer had in mind, but who was from outside the EU, but they couldn't necessarily go ahead and employ them, offer them a job until they'd first of all advertised, throughout Europe, the so-called resident labour market test. And I think you're suggesting that that's no longer there, and therefore there's no longer a need to be very, very specific. The individual must be able to.
Yes, indeed. Yeah, I mean, I remember, you have to jump through all these hoops, and often it's ridiculous because you've got the candidate chosen already, and you've got to go through an artificial process. So they've done away with that to a degree that it's not compulsory. But what is interesting is that if you do advertise the job, then you still have to show them how you came to that process to choose the non-UK worker. So it depends really on what your recruitment process is for that particular job, whether you have to keep and show the records or not.
I see. And what's happening to the shortage occupation list, which was also, it was kind of you get into the UK free kind of card as it used to be?
Yeah, the shortage occupation list is still there. It's less useful than it was before because the main advantage of it before were the lack of having to advertise and potentially lower salaries. But both of those things have been brought into the main skilled worker visa now. It still has its relevance though for things like the health and care visa, and when applicants come to apply for settlement, there's this strange rule about a minimum salary for settlement, which doesn't apply if you're on the shortage occupation list. So it still has some of its benefits, but it's definitely been weakened.
It's interesting, isn't it? And is it whether they've ever been on the shortage occupation list, or do they have to be?
Yeah. If they've ever been, say you've been on a 5-year visa, if your occupation has ever been on the shortage occupation list, then you don't have to meet that minimum salary requirement.
Okay, it's kind of recognition of the service that you've provided to the UK.
Exactly, yeah.
in providing your specialist skills. You mentioned in relation to getting a sponsorship license, I think a number of our clients will already have sponsorship licenses, but there may be companies in the group. There may be, certainly conglomerates or international groups, or even just UK focused groups with many different subsidiaries, where maybe one of the companies in the group has a license, but not the specific company that is looking to employ the foreign worker. Can a company rely on a sponsorship license that has been obtained by another company in the group?
No. You have to reapply for that particular entity.
Okay, and so they wouldn't even be able to have the sponsorship license holder engage the individual and then do a sort of intra-company internal secondment. That simply, you can't do that from what you're saying.
No, it would be a breach of the sponsorship rules, because when you apply for the certificate of sponsorship, you have to specify where that person's going to work, and obviously if it's at a different address than where the Home Office are expecting them to work, then it may well be discovered and you could lose your license.
I see. And then again, still on the issue of sponsorship licenses, you mentioned it might be a visit from the Home Office to check that, or there may be an audit of files. And you mentioned sponsorship license holder duties as well. What exactly are, or what are some of them, and what's the consequences of not getting?
Well, I mean, the record keeping, for example, is quite onerous under a sponsor license, a lot more than often a company's own HR department would have, or it may well be records that are kept in various different places within an organization and therefore not readily available. So, for example, a lot of companies have right to work checks, but for Home Office sponsorship holders, they go beyond that. So you have to have a copy of the passport, but it has to be signed and dated by the authorizing officer of who's holding the license, and it has to be checked at least once a year. You need to have reminders on your calendar of when people's visas are running out. You need to be able to identify where people are, whether they're attending work every day that they're sponsored. So again, there's potential issues there with remote working as well.
Yeah. And I guess whilst most employers will say, keep us up to date with, if you change your address or anything like that, they don't really, necessarily proactively enforce that, or have penalties if employees don't do that. But if they're an immigrant employee who've come in under a certificate of sponsorship, if one of the obligations is to always be aware and maintain an accurate record of that, and failing to do so would be a breach of your obligations, your duties as a sponsor, then I guess, I've seen and I've drafted contracts where, they've been that much more specific about, the obligation on the employee to make sure that the employer is always aware of where they are, and actually it becomes a fairly serious breach and disciplinary matter if they don't do that.
Yeah, because it has a domino effect, especially if you have more than one employee sponsored. If you lose your license, it's going to affect not just that one employee, but potentially a lot of employees and your bottom line as well.
And that's one of the consequences of failing to adhere to the employer duties, the license holder duties, is you could potentially lose your license. I'm guessing perhaps not if it's a minor breach first strike, but if you've got a number of employees and there's evidence to show that you don't, that you've got inaccurate addresses for all of them, just to use that example, then that on totting up, then you could end up with not only a fine but losing your license.
Yeah, definitely. Yeah, that's the ultimate sanction they can have, and that can be quite disastrous because then you can't reapply for a license for another 12 months.
Yeah. I mean, does this have any it seems from what you're saying and some of the reading I've done around this that although obviously part of the reasons for why we are where we are is concern about too much immigration, but it may well be that the records will show that immigration has gone up as a result of this new approach. Would that be fair?
Yeah, I think so. Yeah, but I think this is what the government wants. The government wants managed migration, managed by them, whereas under free movement of workers, they had no control over it.
So yeah, I guess that's right. Whereas in the past there was a bit of a free for all, and the records weren't necessarily kept, and we probably didn't really know how many migrant workers we had. Under the new regime, we will at least know, because they're going to have to be on certificates of sponsorship, whereas previously, obviously, the EU workers didn't have to be.
I have no doubt it's going to go up. At least these type of visas are going to go up. I don't know if we'll ever reach the same levels of migration as we were under free movement, but certainly I think the need in the workplace is there.
And you mentioned, I think, if somebody comes over under certificate of sponsorship, their partner and dependents can all come over as well. And am I right? The partner can actually then do any job, or indeed, set themselves up.
It's a strange quirk of the system that although the main lead applicant is tied to the employer who sponsors them, their partner can do anything. There's no restriction.
Interesting. And then just final one from me, and again, if anybody had any questions, pop them on the chat. But does this have any impact on unskilled workers? We heard a lot in the past about, fruit pickers, agricultural workers, seasonal workers coming over from, often it was Bulgaria or Romania. Will that be impacted at all by this?
It won't be. The government is still keeping control of that under the Tier 5, the temporary workers. But as I said, a lot of jobs that were considered unskilled previously have now been brought into the skill level of skilled workers, the level 3. For example, senior care workers are now qualifying for skilled worker visas, whereas they didn't before. And I think the last time senior care workers were on the list was about 5 or 6 years ago. So it's quite a significant change.
Yeah, I mean, that is important, isn't it? Because I mean, we do hear about a lack of sufficiently qualified people in those roles. I was hearing one thing also about drivers. Am I right in thinking drivers are not under this new regime? That currently they can't come in?
Yes, I mean, unfortunately, the Home Office have not classified them as skilled workers as yet. I mean, I know there's a lot of pressure and campaign from the haulage industry to change that. But at the moment, I think the government are hoping that just the temporary permits to let them come in and make deliveries and pickups is enough. But I don't think it is.
No, I mean, that allows people who are based abroad to come in and out, but it doesn't allow foreign workers who employers need to be based in the UK. It doesn't do anything for them, really, does it?
No, it doesn't at all. No. Yeah.
Okay.
And I think this reflects the way that the whole of Brexit has been rushed through.
It's interesting, isn't it? And potentially on that bombshell, unless there's any other questions that people have, I think we've probably reached the end of our time. So thank you, Chris, for your presentation, for answering those questions as well. I found it really useful. Hopefully those joining us live have, and those who watch the recording will as well. And just time to say there's one more in the series which happens next week, which is in relation to the graduate scheme, where again there's been significant changes. So we'll look forward to same time, same place, hearing from Chris in part 3 of his webinar series on the graduate scheme next week. Thanks again, and have a good rest of the day.
Thank you very much for joining.